Hi, everyone. In this lesson, we'll be talking about religious discrimination in the workplace. So, under Title VII, employers have a duty to reasonably accommodate an employee's conflict between religion and workplace policy. This is one of those protected classes where this duty to accommodate attaches. Now, that is as long as the employer has 15 or more employees, at least at the federal level. Your jurisdiction could cover businesses smaller than that. You just have to understand where you're operating. And unless the accommodation would cause the employer an undue hardship. Much more on undue hardship later in this lesson. We will state from the get-go here that religious organizations are exempt from many prohibitions against religious discrimination. So as we're reading through here, you shouldn't read that, oh, they're going to force my church to do this or that, because your church is probably exempt from what we're talking about in this lesson. So this includes educational institutions owned in whole or in substantial part by a particular religion, as well as, of course, churches themselves, or really any other organization that's owned by a church or a religion. So there's two things here. There's a technical difference between the two. One we call the religious organization exception. And this means that religious organizations can show preference for members of their own religion. So if I'm a church, and it's a Christian church, then I can show preference for people who subscribe to the Christian faith. And so on for the Jewish faith, for Muslims, for just pick any whatever religion you want. They're all covered in the United States. Now, that religious organization exception can apply even if the employee is performing secular duties. So it doesn't just have to be employees who are performing these religious duties. This does not allow the churches or the religious organizations to discriminate on other protected classes. However, we can't just discriminate based on race, color, national origin, sex, all the other protected classes covered under Title VII and other legislation in the United States. But on religion, sure, this exception is granted. A little bit different for ministers, though. We call this the ministerial exception. This is an attempt under the First Amendment to try to keep government regulation out of choosing religious administration. Who are the people that are going to be leading the church? So clergy members generally cannot bring claims under federal employment discrimination laws, which includes Title VII, the Age Discrimination and Employment Act, the Equal Pay Act, the Americans with Disabilities Act, which essentially means that churches would be free to discriminate on these bases when choosing their own church leadership. Maybe it's not great policy to, but they're probably not going to be sued for it successfully. Probably, law is a constantly evolving thing. And so something crazy could happen. This applies only to employees who perform essentially religious functions, namely those whose primary duties consist of engaging in church governance, supervising a religious order, or conducting religious ritual, worship, or instruction. So two exceptions there allowed for religious organizations that won't be available to private businesses. So with that, I only mention that because some people, religion holds a special place in a lot of people's minds and in their lives. And as we're discussing things, people can get nervous about certain things. So I state those exceptions from the get-go. The rest of what we're going to be talking about is mostly about just private businesses, government institutions, stuff like that, where this religious discrimination protection kicks in here. So first we can define what religion is, or at least ask ourselves the question, what is religion? Have you ever had to sit down and write a definition? It can be a little bit harder than you might think. So some questions to ask yourself when considering whether something counts as a religion is the employee's belief closely held? Okay, not every closely held belief is religious, but religious beliefs typically are pretty closely held. Does this take the place of religion in a person's life? The belief doesn't have to involve the belief in a religious deity. The employer doesn't have to be familiar with that religion or have even heard of that religion. And this came from a case called Frazee versus Illinois Department of Employment Security. I linked that to you in the notes so you can learn more if you're interested. So that means things like atheism or agnosticism, any of the mainstream religions, even non-mainstream religions that you may or may not have heard of, can count as religion and can be protected in the workplace. Post 9/11, there have been some things happening in American society where a lot of people are very nervous or apprehensive around people, especially of the Muslim faith, just because of what happened. So sometimes you might have somebody show up with some type of religious garb, and that could make people nervous or uncomfortable. So what if I find out that coworkers are uncomfortable with what somebody's wearing when that is part of their religious beliefs and practices? Well, that's not going to really matter. The coworker's discomfort there isn't going to really matter. As long as company policies allow a person to wear religious garb, then they should be allowed to. What about when religious beliefs appeared after a person was hired? So when they hired them, they didn't request any time off, they didn't have any special concerns, but then they converted to some faith later on. That won't matter. The duty to accommodate will attach to the conflict itself, not to when it arises. So the moment when somebody comes to me and says, hey, I have an issue with scheduling or break times or whatever it might be, that's when I need to sit down and have a conversation about them regarding whether an accommodation needs to be made. So we can talk about this duty to accommodate a little bit more. So once an employer is aware of a conflict, now the employer must make a good faith effort to accommodate, and the employee must assist with the accommodation. If the employer has exhausted all options that don't present an undue hardship, then the employer no longer has liability under Title VII. This applies even when an employer's behavior is religiously based. The accommodation might not be needed if doing so presents real problems to the employer. We'll look at some examples of real problems and what that might mean in a little bit. Any reasonable accommodation will do. It doesn't need to be the most reasonable accommodation. It doesn't necessarily need to be the one that the employee wants, but any accommodation that would be reasonable, that would allow the business to keep functioning, for the employee to keep working, probably is going to cover a business if it ever makes its way to court regarding liability. An employee must be reasonable in considering accommodation alternatives. Again, we can't just get fixated on only one potential accommodation. We have to be reasonable and reasonably flexible when trying to seek this accommodation. Some examples of common religious accommodations can include, but are not limited to, flexible scheduling, voluntary shift substitutions or swaps, job reassignments, and modifications to workplace policies or practices. So there are a lot of options there. A lot of the conflicts regarding religion will have to do with taking time off, either for like a religious day of the week, or for religious holidays, or for wearing some type of religious garment or something like that. These are the common conflicts, but over time we discover more and more things. Okay, the courts and the EEOC will consider when we're looking at whether the employer made a good effort to accommodate, we'll look at things like whether the employer made a good faith attempt at accommodation, what was the size of the workforce, what's the type of job, did the employer check with other employees to see if anyone is willing to help with the accommodation? What is the dollar cost of the accommodation? What are the administrative aspects of an accommodation when we're trying to consider whether the company made that good faith effort? Now, there's been a big change very recently when we look at what constitutes an undue hardship. And this came out of a Supreme Court of the United States decision in Groff versus DeJoy. In this case, we find, or the court found, that Title VII requires an employer that denies a religious accommodation to show that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. This is a major shift because this replaces an older standard that we call more than de minimis. Under the more than de minimis standard, anything that caused more than this very minimal cost would be considered an undue hardship. And now we're increasing that, or raising that bar from anything more than the bare minimum up to what we call substantial increased costs standard. So it'll be much harder for a company to prove that, well, this would have caused me an undue hardship. So an undue hardship is shown when a burden is substantial in the overall context of an employer's business, taking into account all relevant factors in the case at hand, including the particular accommodations at issue and their practical impact in light of the nature, size, and operating costs of an employer. An accommodation may cause an undue hardship if it is costly, if it compromises workplace safety, if it decreases workplace efficiency, if it infringes on the rights of other employees or requires other employees to unwillingly do more than their share of potentially hazardous or burdensome work. So this is the biggest major change as far as religious discrimination, religious accommodation, is the raising of that standard from more than de minimis to substantial increased costs. So that's just something to keep in mind if you're planning on working in HR, or if you're currently working in HR and trying to figure out how to write your company policies. Let's talk a minute about dress and grooming policies. So when an employee or applicant needs a dress or grooming accommodation for religious reasons, they should notify the employer that they need an accommodation for religious reasons. So that's part of this accommodation process here. I, as the employee, have to notify the employer that there's some type of conflict or I need some type of accommodation. Then the employer has an obligation to try to work with me to try to find this accommodation. And as long as we can find a reasonable one that doesn't cause an undue hardship, then everything should be okay. Okay, so regarding these dress and grooming policies, some accommodations might include, these are for example, but they're not, of course, going to express every accommodation that might be necessary. But wearing a particular head covering or religious dress, such as a Jewish yarmulke or a Muslim headscarf, wearing certain hairstyles or facial hair, such as Rastafarian dreadlocks or a Sikh uncut hair and beard. It also includes an employee's observance of a religious prohibition against wearing certain garments. Some religions prohibit women from wearing pants or mini skirts. Matter of fact, there was a case in North Carolina where I believe it was a woman working at KFC, and she refused to wear pants and wanted accommodation to wear her religious, long skirt or dress, and she ended up winning that. Anyway, if the employer reasonably needs more information, the employer and the employee should engage in an interactive process to discuss the request. If it would not pose an undue hardship, the employer must grant the accommodation. Okay. Shifting a bit into harassment. So, the discussion of harassment here will sound very similar to other discussions of harassment we've had. And that's because the standards for harassment are largely the same across all the protected classes. So, it is illegal to harass a person because of their religion. Harassment can include, for example, offensive remarks about a person's religious beliefs or practices. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that aren't very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive working environment. So we've heard this hostile environment topic before. Or when it results in an adverse employment decision, such as the victim being fired or demoted. So we remember this conversation from the sexual harassment lesson that we had, where there was the quid pro quo version, then there was the hostile environment version. The same thing holds here. We don't call this quid pro quo in the context of religious harassment. We just say that it's harassment that results in an adverse employment action or decision, where there's a much easier time of proving the case because there's a paper trail involved, versus establishing that there's a hostile working environment. Now, the harasser can be the victim's supervisor. It could be a supervisor in another area. It could be a coworker. It can even be people who aren't employees, like clients or customers. Employees will be protected from harassment from anyone in the workplace. Okay, so good employer practices, just some things if you're looking for a few management tips regarding harassment specifically. We should protect employees from the religious employees who attempt to proselytize others, who do not wish to be approached about religious matters. So if somebody comes to you and says, Bob won't stop talking about his religion, trying to get me to come to his church, I've already told him no. Kindly, can you please do something? Then I should probably step in as the employer and go have a conversation with Bob about, how he's already fulfilled his duty and he no longer needs to talk about religion in the workplace. I should protect employees with permissible religious practices who are given a hard time by those who believe differently. This could be somebody who just eats something specifically, refuses to eat something specifically, or feels like they need to have prayer time at certain times of the day, or whatever those practices might be. If we find that people are making fun of, giving people a hard time, harassing them, then we need to step in and correct that and prevent it from happening in the future. And then finally, make sure that employees are given comparable opportunities to use workplace time and resources for religious practices. So if I'm allowing somebody time off for their religious practice, I should allow somebody else time off for theirs, and allow that equal opportunity to use that time and those resources, whether it be a space for prayer or whatever it might be. It is a violation of Title VII to discharge an employee for refusing to join a union because of religious beliefs. We haven't really talked about unions yet. There will be a chapter on that later on. But there are some states where if you're not a member of the union, then you can potentially lose your job if you refuse to join. But then there would be an exception for somebody who refuses to join based on religious beliefs. Now, this is not a thing in North Carolina, really, but if you find yourself working in another state where the laws are different, then that's something you should be aware of. How about some overall management tips regarding religious discrimination in the workplace? An employee cannot be forced to participate or not to participate in a religious activity as a condition of employment. And just so you don't think I'm being crazy here, there was a company I believe they're out of Greensboro, called Aurora Pro Services, who they're a home repair company. Prior to work every day, all the employees were supposed to gather around for prayer and devotion time. And the company owner just made it clear that this was mandatory and people couldn't opt out of it. He ended up having a couple of atheist employees who requested to be excused from these prayer and devotion times. They were subsequently fired because they wouldn't participate, and then they sued. The EEOC sued on their behalf, and Aurora ended up having to pay, I think, around $50,000 or so. So this is the kind of thing that can still happen. That happened within the last few years. Take all employee notices of religious conflicts seriously. Don't just dismiss somebody because they might sound a little bit crazy right offhand. Let's at least sit down and hear them out to see if there's actually a real accommodation that needs to be considered here. Once an employee puts the employer on notice of a religious conflict, immediately try to find ways to avoid the conflict. So this might involve asking the employee with the conflict for suggestions on how to avoid the conflict, and asking other employees if they can be of assistance in alleviating the conflict. Keep workplace religious comments and criticisms to a minimum. That's a good way of trying to reduce the amount of religious conflict in a workplace, especially when you have people of different religions interacting in one environment. The more you talk about it, the more potential there is for conflict to arise. Make sure all employees understand that they are not to discriminate in any way against employees on the basis of religion. Once an employee expresses conflict based on religion, don't challenge the employee's religious beliefs, though it is permissible to make sure of the conflict. So what that means is, I shouldn't sit down and say, well, somebody tells me the Bible says I shouldn't work on Sunday. That doesn't mean that I need to go in and start saying, well, actually, the Bible says X, Y, Z, A, B, C, D, challenging their beliefs if the belief is sincerely held to them. Even though it might not be part of mainstream religion, it can still be protected if it's their closely held, sincerely held belief. But if somebody says, well, I subscribe to this religion, Pastafarianism, that maybe you've never heard of, I can at least go in and make sure there's an actual conflict here and sort of like, poke around and see if these are actually sincerely held beliefs, if there is actually a religion called that thing. I can at least poke around just to see if these are sincerely held beliefs rather than just some employees' attempt to try to not show up for work. I just have to be careful the way I approach that. Make sure undue hardship actually exists if somebody's claiming that there is one. If I have a manager, if I'm trying to make an accommodation for an employee of mine, and management above me says that we can't do it because there's an undue hardship, I should do my due diligence to actually verify that, just to protect the company later. Sometimes we may end up having to protect management from themselves if we have the leeway to do that. You know your situation better than me. See if it is more appropriate to use more inclusive language in the workplace. So this is gets to that controversy that pops up every year where somebody says, well, why are companies changing over to saying Happy Holidays instead of Merry Christmas or whatever? There's a few different versions of this. It's not necessarily that a company is trying to erase Christianity from societal mainstream. It's just that they're trying to use terms that can be more inclusive of other people and other religions. And if we can settle on one word that sort of covers everybody, such as holiday, then maybe that's easier for us to use and to train our employees on, rather than, big, long, elaborate things to say to try to cover every religion out there that might be celebrating a holiday during this time of year. We should always revisit the issue of whether all employees are being fairly covered by policies and events when we're looking at like holiday time, break time, stuff like that. Not everybody celebrates or subscribes to Christianity in our society. So are we allowing people of different religions to have time off for their religious holidays, for example? We should revisit the issue of granting leave for religious events and make sure it does not favor one religion over another, along the lines of what I was just saying. And finally, make sure food at workplace events is inclusive of all employees, regardless of religion. I'm not going to get in super big trouble if somebody makes a mistake and we have like a company picnic and we accidentally or maybe we didn't know that somebody had certain dietary restrictions and somebody made a mistake. It becomes a bigger issue if somebody requests accommodations and then those accommodations aren't made, especially when it happens repeatedly. Then it's the kind of thing that can potentially get me in trouble. But those like one-off sort of mistakes usually aren't the kind of things that cause a whole bunch of company liability. At the end of this lesson, I gave you a bunch of case examples so you can see different versions of how religious discrimination or failure of accommodation has happened. I try to start with the most recent and then move all the way down. One of the most recent ones that happened was this EEOC versus Suncakes, North Carolina. This decision just came down a few days ago. For me, when I'm recording this in 2024, there's a Charlotte IHOP that had a Christian employee who requested not to work on Sundays. And initially, the IHOP granted this accommodation and figured out how to cover those Sunday shifts with other employees. But then a new manager came in and didn't like this accommodation, so they reversed it. The employee refused to work on Sundays. The manager was requiring them to work on Sundays, so then the employee was fired. And the ultimate settlement was that IHOP has to pay $40 to the employee, $40,000 to the employee, provide annual training to managers, post a notice to employees about the settlement, and then go back in and revise their policies. So it's just an example of how failure to accommodate can end up costing you a lot of money and a lot of hassle and a lot of heartache, where maybe it would have been easier just to make this good faith effort to try to accommodate. I'm not going to read all these cases to you. For those people who are interested, you can read through and you can even look up the case citations to read more about the cases if you'd like. For now, I'm going to leave you to it. I hope you all have a great day.